Human creative works and technological progress play a central role in our lives, from the books we read to the lights illuminating our world. And while a book or a light bulb is a tangible thing that can be held, you can't hold the words on the page or the design of a light bulb. For the past few centuries, the law has granted legal rights in these human-created intangibles. These rights, typically referred to as intellectual property, grant someone the legal power to limit other people's use of that intangible. But what does it actually mean for someone to have rights in creative expression, or inventions, or other products of human imagination? This course will explore those questions. Let's begin with a simple question. What is property? You might be thinking, well, property is my stuff. It's my pen, my smartphone, or my lunch. Or maybe you think of property as land, a farm, or a house. Most people think about property in these terms, as things or land or buildings. But people who know law think of property not as things, but as the legal rights over that thing. For example, if we're discussing land, property can include the right to stop other people from coming onto that land without the owner's permission. Or it might be the right to transfer that land to someone else. For lawyers, property is less about the res, the thing in Latin, and more about the legal rights associated with that thing. Intellectual property is the same, but rather than legal rights over a thing, it involves legal rights over intangibles. But what's an intangible then? When we're discussing legal rights and physical property, we're talking about legal rights attached to that thing. But when we're talking about intellectual property, we're talking about legal rights over something that's intangible. I'll illustrate with this Thomas train. It's a thing. Someone can own it. If someone else comes and takes this toy without the owner's permission, that person is violating the owner's property rights in this thing. On the other hand, when we're talking about intellectual property, we're not talking about rights in this specific thing. We're talking about rights in what makes this toy a Thomas train, the intangible aspects of it. So for example, just because someone owns this particular toy doesn't give that person the right to make a dozen identical Thomas trains, because the owner of this particular toy doesn't have rights in what makes this toy Thomas. Intellectual property rights relate to these kinds of creative intangibles. You can own a book, or a toy, or a machine without owning its intangible aspects. The words on the page, or what makes the toy Thomas train, or the design of the machine. Before we start talking about types of rights in creative intangibles, it's first necessary to understand what legal rights are and some basic concepts for framing intellectual property rights. Generally, I think of laws involving two basic questions. First, am I allowed to do something? And second, can I stop others from doing something using the law? For example, does the law allow me to build a fence around my property? Or if my neighbor builds a fence on my property, can I use the law to stop them? In intellectual property law, these somethings are creative intangibles. They're creative expressions, inventions, information, and so on. So the basic questions for intellectual property law are first, am I allowed to use a certain piece of information, or invention, or creative expression? And second, can I stop others from using a piece of information, or invention, or creative expression that I have rights over? Another dimension of the law that's important for understanding intellectual property rights is how formally they're defined. Some intellectual property rights are highly formalized. For example, a utility patent is a formal government document that grants legal rights in a specific claimed invention. And patent law itself is statutorily codified in federal law. But rights in creative intangibles need not be so formal. Imagine, for example, that someone copies parts of a book that you wrote. Even in the absence of a statutorily codified copyright system, I bet you would still be able to come up with a pretty persuasive argument that the copier took something that belonged to you. You wrote down the words, and then someone else came and stole your words without your permission. Sure, having a formalized copyright system may have benefits, but legal rights can still exist even when they're not as formally defined as a patent. Indeed, the very first case that you'll read in this class, INS versus AP, involves a very informal right in creative intangibles, the tort of misappropriation. In this course, I'll also be talking about sources of law. Some intellectual property law, particularly patent and copyright law, is exclusively federal, while other intellectual property law, such as trademarks and trade secrets, is both federal and state. And in a few areas, we'll see some intellectual property rights that are based exclusively on state law. Finally, most of the intellectual property law that we'll discuss in this course is civil, as opposed to criminal law. In other words, it involves intellectual property rights owners asserting their rights against other people. Criminal law, in contrast, involves the government invoking its criminal powers to prosecute those who violate the law. While the government does have the power to prosecute some violations of intellectual property rights, the bulk of intellectual property takes place in the civil context. Now I'll give you a brief overview of the main categories of intellectual property rights. Trade secrets consist of information that's valuable to a business and that other people don't know about. Classic examples are the formula for WD-40, or industrial manufacturing processes, or the recipe for Popeye's fried chicken. The simplest way to prevent anyone from learning about information that only you possess is, of course, to not share that information with anyone else. Businesses know this. When they develop valuable information, they typically try to restrict who knows about it and keep it a secret. But there's a big limit to not telling anyone about your secrets. It's very difficult to run a business where only one person actually knows what the secret is. You need people who are going to build the machines, buy the ingredients, and make your products. It's really, really hard for a business to rely purely on secrecy alone. So the law provides a legal claim called misappropriation of trade secrets. If someone uses or discloses a business's trade secrets without the trade secret owner's permission, the owner can bring a legal claim against the misappropriator. For example, if an employee breaches a confidentiality agreement and shares their employer's trade secrets with a competitor, or uses the trade secret to start their own business, that could be trade secret misappropriation. Another thing to know about trade secrets is that they're a pretty informal type of right. There's no central registry for trade secrets, and often their specifics aren't explicitly articulated until misappropriation occurs and a lawsuit is filed. In contrast with trade secrets, patents are a very formal legal right. Patents are legal documents that are issued by the federal government after an examiner determines that an invention meets the requirements of patentability. The most common type of patents are utility patents, which grant inventors legal rights over useful inventions. You might be familiar with some famous patents and their inventors, Thomas Edison and the light bulb, for example. Unlike trade secrecy, patents can protect inventions even if disclosure of the secret is inherent in the product itself. For example, as soon as Thomas Edison began selling incandescent bulbs, trade secrecy could no longer apply. Everyone could see the basic design of the light bulb. With a patent, Edison had an exclusive right to the invention for the term of the patent, providing a tremendous competitive advantage. The main requirements for patenting an invention are that the invention must be new, it must not be obvious, and it must be adequately disclosed in the patent application. These requirements are assessed against the patent claims, which are formal written descriptions of the invention at the end of the patent. Once the patent office has issued a patent, its owner can then bring a claim of patent infringement against someone else who is making, selling, using, or importing the claimed invention. While patents grant rights over inventions, copyright provides legal rights in creative expression: books, movies, songs, plays, photographs, and sculptures. We call these works of creative expression. Copyright protection requires a few key things. First, copyright grants rights to recorded creative expression. You might be walking around humming a new song to yourself. You don't yet have a copyright in your song. But once you write down the notes or record it, you could have a copyright, as long as it's actually your song, not one that you copied from someone else. Which takes us to the second core requirement of copyright protection: originality. To be protected by copyright, creative expression must have actually been created by the person claiming rights. If they just copied the creative expression from somewhere else, the copier doesn't have copyright, although the original creator might. So when I show you this clip from Steamboat Willie, I don't have copyright in it, although Walt Disney did for a while. Just as with patents, copyrights have a limited term. In the case of copyrights, though, it's a lot longer than patents. Steamboat Willie was published in 1928, but the copyright in it only expired at the end of 2023. In addition, whereas patents provide rights that are good against anyone, copyrights only apply against people who copy a protected work. So that means that if you write a book, copyright grants a right to stop other people from making copies of your book, and it lets you stop other people from publicly performing your work without your permission. Trademarks are source identifiers. These are how customers know a product or service comes from a particular origin. When you go out for a Big Mac to the place with the golden arches, you know it's a McDonald's. You know that you're going to get the same kind of Big Mac that you get every single time you go to a McDonald's. That's the essence of a source identifier. It's how consumers know where a product comes from and engage in repeat business. Trademarks allow companies to differentiate themselves and consumers to build repeat relationships with their preferred goods or services. A trademark can be basically anything that functions as a source identifier. Usually we think of these as words or logos, but could also be a combination of colors or really anything that's capable of conveying meaning. If I see black shoes with red soles, I know that they're Louboutin.
And I'm scooting in Louboutins.
Even a scent can be a trademark if it functions as a source identifier. Trademark law works by granting the owner of the trademark the right to prevent others from using the mark, but only in a way that's likely to cause confusion among consumers. So that's why my use of these marks is not trademark infringement. You're not thinking that I'm Starbucks or that I'm selling you Starbucks coffee or that I have any affiliation with Starbucks whatsoever. There are other types of intellectual property rights beyond these four. One that's become increasingly prominent is called the right of publicity, which is the right of an individual to the commercial exploitation of their identity. Think about Caitlin Clark and all of her endorsement deals. The right of publicity prevents other companies from selling their products using her fame. Regardless of the type of intellectual property, however, each of these categories confines legal claims involving intellectual property to specific sets of rules. To be protectable by copyright, for example, a work must be original. To be protectable as a trade secret, the information must have value from not being known to others. The rules governing these categories channel both behavior and legal claims over creative intangibles into specific pathways. But what if the creative intangible that rights are being claimed over doesn't fall into any of these categories? Is it still possible to articulate a legal claim? The first reading for this class, International News Service versus Associated Press, involves this question. Throughout this class, you'll be reading both statutory law and judicial opinions. We're going to begin with a 1918 Supreme Court decision called International News Service versus Associated Press. This case is a classic and illustrates some of the fundamental issues in legal rights and creative intangibles. You can find it at the Introduction to Intellectual Property Pressbook site. Before you read this case, I'll give you some context. The International News Service and Associated Press were two large news services that local newspapers could subscribe to. The idea behind news services is that they can aggregate news among their local members, allowing a newspaper in Iowa to report on what was happening in New York City or San Francisco. Membership fees also let these news services maintain reporters in places where they didn't have local affiliates, such as England and France. At the time this case took place in the first part of the 20th century, instantaneous long-distance communication was possible. Telephones existed, but the primary mechanism for long-distance communication across the Atlantic Ocean was British telegraphy cables. This made these cables very important for obtaining news from Europe, especially during the period 1914 to 1918, World War I. The problem for the International News Service was that it had lost access to these cables by angering Britain and France. As a result, it could no longer obtain news reports from its correspondents in Europe. Yet it was publishing news on the war in Europe. So where was it getting its news? The Associated Press argued that INS was actually getting its news on Europe from Associated Press newspapers and bulletin boards. The Associated Press's legal theory was that by copying its news, INS was engaged in misappropriation. What exactly this theory of misappropriation is something you'll need to consider as you read this case. Since this is the first reading assignment for the course, I'll briefly talk about how you should approach it. Each reading assignment is accompanied by a series of questions in the prefatory reading. As you read the court's opinion, consider these questions. Stop the presses, boss! I got a great story for Above the Fold. Oh, hi there! Just got a tip. Anonymous sources tell me you're gonna love this case. See you next time.